undergraduate and law degrees. He was a deputy district attorney with the LA District Attorney's Office for almost 5 years. Since then, he's been engaged in commercial collection and enforcement of judgments. Mr. Greenbaum is a senior attorney with the law firm of Greenbaum Law Group, LLP. All lawyers and paralegals in his law firm limit their practice to judgment enforcement and commercial collection cases. Its website is collectionlaw.com and sisterstatejudgments.com. Mr. Greenbaum is an AV rated by Martindale Hobble Law Directory. He also does multiple foreign judgment and arbitration award collection matters. And I think you're in Newport right now at your firm?
I am in Newport Beach right now, sitting in my office.
Okay, rainy or not rainy?
Rained about 2 hours ago, not raining now.
Okay, I was driving up the 7th Street this morning to the office and it was raining like cats and dogs, so
Yeah,
anyway.
It rained for about 20 minutes, and it did rain, but it's okay. No blue sky, though. No blue.
Well, just,
Okay,
you know,
are we doing MCLE for this?
no,
Okay,
we're not doing MCLE.
okay, most of this is MCLE. If you later decide you want it certified, I'm sure you're an MCLE provider and you can certify it if you want. Okay.
That's a great point. Okay, I will definitely look into that. That's a great point. Yeah.
Okay,
So,
tell me when you're ready for me to start.
okay, just so everybody knows, this is going to be a discussion of enforcement of judgments. I think we can all read the Rudder Group for basics like you need to renew your judgment every 10 years. There's certain ways to collect, the basic ways. You can slap an abstract of judgment on the property, or you can, after a hearing and take certain information, you can garnish wages, garnish a bank account, maybe even take a car, do a tail tap. That kind of sounds exciting, or a keeper. So those are the basic ways. However, it's easier said than done. Like with an abstract of judgment, what if it's not the person? What if it's the entity? Like I've never had to deal with that. So we're turning to you. Maybe you can share your thoughts about how to deal with enforcement of judgments, any information you might share, and what we as civil attorneys, doing pretty much civil prosecutions and lawsuits, what we can put in our stipulated judgments to try to help us should we find ourselves in an enforcement of judgment situation.
Okay. Well, enforcement of judgments is a common topic, and there's lots of MCLE courses on it. And this is not about following a book. And if you just do what's in the book, you'll get all the statutes, you'll get all the cases, you'll get all the textbook approach. And the common book, Rudder Group, Enforcement of Judgments, everybody's got one. If you just do that, you're not going to get very far, but that's the basic thing. The first thing that you need to do in a judgment enforcement case, make sure you have a judgment. I see a lot of judgments where people started out against a particular entity, and it turned out that entity was either spelled wrong, didn't exist, was FTB suspended, was Secretary of State suspended. They get a judgment against somebody who doesn't really exist by the time the judgment is entered. So make sure that you really have a judgment debtor in the case. Make sure that you have an actual judgment. And when we're talking about enforcement of judgments, we're talking about money judgments. It's got to say who the creditor is, who the debtor is, how much money is owed. And it's got to have the correct names, and it's got to be signed up by the judge, and you need to have an available copy of the judgment to enforce it. Now, there are multiple ways to enforce a judgment. The one that most people look to is, how do I take something away from a debtor? How do I take something away? We'll talk about that for a minute. But the better way is, how do you make the debtor want to pay you? So this is where the psychology of judgment enforcement begins, is we want to make him pay you. We want him to come to him, her, but we'll use in the alternative. Him, her can come and they'll want to pay you. They'll want to offer you a settlement. They'll want to start negotiations. It's much easier when they come to you and they say, how can we resolve this judgment? And so you take something away, that's an incentive. You make the debtor want to pay you, we're going to go into that. You make somebody else want to pay you. Sometimes there are junior lien holders who want to buy your lien, who want to pay you off. There are senior creditors who want to keep their, or not senior, there are senior creditors who you can become senior to, who you can jump ahead of, who want to buy out your lien. And you need a collection plan for this, and the plan has to be fluid. It has to adapt to what happens. Now, the routine things after a judgment is entered, which this is all the boring part of it, is make sure that either the clerk has given notice of entry of judgment or you've given notice of entry of judgment. That starts the appeal clock running. You'd rather have 2 months of time for them to file a notice of appeal on a judgment if it was a litigated case or a default judgment case instead of 6 months. So notice of entry is important. Do it quickly. Record all liens. That's the classic mistake that most people make. A judgment lien on personal property, it's a judicial counsel form, it's a JL1. You can do it online. You don't have to give notice, you don't have to do anything. It's with the Secretary of State, it costs $5, and it is basically the equivalent of a UCC1 filing, and it makes you a secured creditor. So immediately file your JL1, I mean hours after your judgment is entered, file your JL1. Get your abstract of judgment from the court. Theoretically, pre-COVID, pre-electronics, pre-technology age, you had to go and you had to get one original abstract of judgment from the clerk of the court, and you had to send it to each county recorder's office, and you had to pay for each one. They were $35 a piece. Now they send it to you electronically, and the abstract of judgment, though not covered in the code, and there's no rule or regulation on it, nothing that I've seen, is apparently reusable. But the abstract has to be recorded in the county in which the debtor, or you suspect the debtor's entities or debtor's weaknesses are, in the county in which those are located, the real property is located. And once it's recorded, it becomes a lien on any real property then owned or thereafter acquired. Now, filling out the abstract is a technicality. You don't read this in the book. But who catches abstracts of judgment? Title companies catch the abstracts of judgment. That's who finds the liens, unless you're going to foreclose on them. And so one of the things you want to do in the box where it lists the name of the judgment debtor is make sure you put in the address of the judgment debtor where the real property is located, even if it's in an LLC name or a revocable trust name, whatever it is. All you're doing is filling out where to notify the judgment debtor. You're not claiming a lien on property. Abstracts do not claim liens on personal property. They claim liens on judgment debtors on any property then owned or thereafter acquired. So you can file your abstract even though the debtor doesn't have anything in that county, and if the place to notify the debtor is on that abstract, the title company is going to say, wait a second, don't you live there? Isn't that a trust that you're in? Isn't that one of your single purpose LLCs? Here's an abstract, and they're going to start asking questions. Title companies don't like problems. And so what are they going to do? They're going to hold up a sale. Banks don't like problems. They're going to hold up a refinance. So you want to clue the banks or the title companies that that address might be somehow connected. You haven't claimed the lien on the property. All you've done is listed it as a potential address for your judgment debtor. So get your real property lien, get your personal property lien in there as fast as you can. There's a secret lien. If you're getting all of those threats from the judgment debtors, they always threaten you with bankruptcy. They always say, "I'm going bankrupt. I'm going bankrupt." Serve the judgment debtor with an OJD, an ORAP, a debtor's examination. Once served, even though there is no public knowledge of it, and after 90 days of the preference period, if he files bankruptcy, you're a secured creditor in the bankruptcy, and you jump ahead of the trustee. So even if you don't intend to take the exam, or if the exam, we'll talk about exams in a few minutes, but whatever you do, serve the secret lien if the guy's threatening bankruptcy. Once you've filed all of these liens, and these are all done within the first week. I mean, you got to get movement on these things before anything else happens. Get these liens recorded. If you check the UCC filings, which you can do online at the Secretary of State's office, and you find out that there are senior lenders, the majority of rich debtors have senior secured lenders. They all have a bank or a accounts receivable financing line or a factoring line, or half the time it's their relatives in their own single purpose LLC in Wyoming or something like that. But if the credit line is a revolving line of credit, and you filed your JLPP, your judgment lien on personal property, and 60 days pass, you give notice to that senior lien holder that says, if you make any advances more than 75 days after I have notified you, I jump ahead of you in priority. Now, if suddenly you jump ahead of a senior lien holder, are they going to continue to advance money to that debtor? No way. They're going to freeze his credit line, or they're going to insist that he satisfy your judgment, or they might buy out your lien. And so you want to give your notice, and it's in the book, but when you do it is more important than how you do it. And looking for these liens is crucial. You do it with an UCC search. If you're dealing with people who are licensed, for example, contractors or professionals or something like that, most of these people have various forms of licensing sanction, where if you have a judgment lien, or if you have a judgment against somebody, a contractor, a lawyer, something like that, and they haven't fulfilled that judgment lien, that licensing board will come after them. So check all of the licensing that your judgment debtor may have and find out whether or not there's an appropriate sanction with the licensing board that you're going to do.